Hi there, my name is Drew. I'm a lawyer in British Columbia who helps people understand the law. I've worked for years with nonprofit organizations in BC, so I'm excited to help people learn about a new law that affects nonprofits across the province. As of November 28, 2016, this new law, called the Societies Act, governs how nonprofits are created and run. If you work at a nonprofit or sit on a board of directors, you're likely wondering, what does this new law mean for your society? In this video, I'm going to cover 5 ways in which the new Societies Act affects existing societies. For starters, you will need to transition your society under the new Act. All societies in BC must file a transition application with the government within a 2-year period after the new law comes into effect. What's super important to appreciate is that when a society files its transition application, does not affect when the new law applies. The new law applies to your society as of November 28th, 2016, whether or not your society has transitioned. One result is that any provision in your society's bylaws that is inconsistent with the new Act has no effect as of November 28th, 2016. The matter is governed by the new Act. More on this shortly. First, though, what does transitioning involve? The transition process features filling out a form and uploading documents on the corporate registry's website. The key documents are your society's constitution and bylaws, rearranged to meet some detailed requirements of the corporate registry. A society that rearranges its constitution and bylaws as required but makes no other amendments to its bylaws can complete the transition application without requiring member approval. Optionally, societies can revise their bylaws as part of the transition process. A society that does so will need to have the changes approved by a special resolution of members. In later videos, I'll walk you through the steps of the transition process. A second way the new Act affects existing societies relates to the society's constitution. As part of the transition process, your society's constitution may need to be rearranged with care. This requires an explanation. On transition, the corporate registry requires that any provisions in a society's constitution other than the name or purposes of the society must be moved to the society's bylaws. For example, a society may have a provision in its constitution about remuneration of board members or about the disposition of its assets on dissolution. These provisions must be moved to the bylaws. I'll explain this in more detail in a later video on preparing to transition. For now, one other thing to note about constitutions. Many societies have provisions in their constitution that are designated as unalterable. In other words, provisions that cannot be changed in any way. This may have happened to preserve a fundamental principle of the society, for example, a provision restricting the society's membership in certain ways, or the activities to a certain geographic area. Or a society may have added an unalterable provision to their constitution at the request of a funder, for example, a provision dealing with disposition of the society's assets on dissolution. On transition, any unalterable provisions in a society's constitution, other than the name or purposes of the society, must be moved to the society's bylaws and must be identified as having been previously unalterable. And this next part is really important. They cannot be changed on transition. But after transition, these previously unalterable provisions can be changed by a special resolution of members. And unless the society's bylaws provide for a higher voting threshold, a special resolution under the new Act requires 2/3 of votes cast at a members' meeting. The result is that after transition, for many societies, a previously unalterable provision could be changed by 2/3 of those voting. The new Act offers flexibility to offset this result. In its bylaws, a society can provide a higher voting threshold of up to 100% of voting members. The higher threshold can be set for specific special resolutions. So after transition, a society could choose to require a threshold of 100% of voting members to change a bylaw provision that was previously unalterable, and at the same time retain the new default threshold of 2/3 of the votes cast for other bylaw amendments. A third way in which the new Act affects existing societies relates to society bylaws. Your society's bylaws set out the rules for governing and operating the society. Most organizations have at least some bylaws that are inconsistent with the new Societies Act. In these instances, the bylaws have no effect. The matter is governed by the new Act. But to reduce the risk of confusion for members and directors, it's best to review your bylaws for compliance with the new Act. As well, the new Act presents opportunities for societies to adopt bylaw changes in areas where the new law offers increased flexibility. In a later video, I'll walk through the steps to conduct a bylaw review. A fourth way the new Act will affect your society is you'll need to decide whether to become a member-funded society. On filing the transition application, you'll be asked, does your society wish to designate itself as a member-funded society? This is a new designation for societies that are funded primarily by their members and operate primarily for the benefit of members. For example, private clubs or sports leagues. There are some advantages to this designation. A member-funded society can distribute the society's assets to members on dissolution, and is exempt from some transparency provisions, such as a new requirement that societies must disclose salaries of directors, as well as any employees or contractors earning over $75,000. To become a member-funded society, you must meet a qualification test and get the approval of your members in a special resolution. The qualification test has two parts. First, your society cannot be from a list of excluded societies, which include most notably registered charities, as well as student societies, hospital societies, and several other categories. Second, your society must meet a funding test in the 2-year financial period before the current one. Any funding from public donations and government sources must be below $20,000 or less than 10% of the society's gross income. Something to note, if you don't adopt the member-funded society designation on transition, you will need a court order to do so later. For this reason, and given that there are some important issues to consider in deciding to become a member-funded society, including how it might impact your tax-exempt status and future funding opportunities, if you're considering it, you should seek legal advice before transitioning. And finally, a fifth way the new Act affects existing societies is that your society filings will become electronic. With the new Societies Act, there is a new electronic filing system, Societies Online. The majority of filings are self-serve and immediate. It should be easier to file annual reports and update information such as the name and address information for your society's directors. There are online forms to complete when your society alters its constitution or bylaws. Special resolutions no longer need to be filed with the registrar. In other videos, I'll cover key substantive changes in the new Act that you should know about, as well as how to transition your society under the new Act.